A very good evening to all the guests present here this evening. I, Priyanka Mittal, on the behalf of Lokniti CSDS and Common Cause, welcome you all to the release event of our latest report titled Status of Policing in India Report 2025, Police Torture and Unaccountability. I would like to invite Professor Sanjay Kumar, Professor and Co-Director, Lokniti CSDS, Dr. Vipul Mudgal, Director, Common Cause, and Radhika Jha, Project Lead, Rule of Law, Common Cause, to please come and be seated on the stage. Thank you, sir. I would now like to request Professor Sanjay Kumar for his welcome address to the guests and the audience.
Very good evening, friends. So on behalf of Lokniti CSDS, I would like to welcome everyone who has joined us today evening for release of a report, which is research report, which is titled as Status of Policing in India Report 2025, Police Torture and Unaccountability. And we have consciously mentioned 2025 because we have been doing a series of studies on policing in India along with Common Cause. A special welcome to our esteemed panelists, Mr. Prakash Singh ji, Ms. Brinda Grover, Dr. Amar Jesani, who have agreed to be part of today's panel discussion. A very special welcome to our keynote speaker for today, Honorable Justice S. Murlidhar, who would be delivering today's keynote address. Let me also welcome Professor Suhas Palchikar, who has agreed to moderate today's panel discussion. The Lokniti CSDS and Common Cause has been collaborating since a very long time. I mentioned earlier, we started doing a collaborative study on policing in India since 2018. We have done systematic research on various aspects of policing in India. We did our first report in 2019. We have done 4 reports in the past. This is the 5th report which we are going to release today. The present study probes question of custodial violence and police torture. We have interviewed almost 8,000 policemen. Details of the study is going to be presented by other colleagues. I'm sure the findings of the study will have important and insightful implications for policy reforms and advocacy. For the benefit of those who are present in the room and for others also, we would share the report. It would be shared online once the report is released after today evening. Thank you very much. Again, most welcome to be part of this report release event.
Thank you very much for your address, sir. Moving ahead, I would now like to invite Dr. Vipul Mudgal to share his opening remarks with all of us. Over to you, sir.
Thank you, Priyanka. It's my privilege to welcome you all on behalf of the SPIR teams at Lokniti, CSDS and Common Cause. Let me take this opportunity to very briefly introduce Common Cause. Common Cause is a civil society watchdog. We work on governance reforms and probity in public life. Integrity of institutions is the best way to describe what we do. We do this through research, through publications, and through public interest litigation. Common Cause has been filing PILs, as you know. Some of our PILs, in fact, if I start talking about it, it'll take a very long time. There'll be more than 70 PILs. But the most important of recent times have been the allocations of 2G, allocations of coal, citizens' right to die with dignity, which is also called the euthanasia case or the living will case, the appointment of India's first Lokpal. This was not happening. We do have a lame duck Lokpal, I believe, but it's good to have a Lokpal than not have a Lokpal at all. So you have whatever, it's over to people of India. Whether you want a Lokpal you deserve better, you fight for it. So there are many other cases. There are all the cases that you saw of the transfers and the illegal appointments of CBI directors, illegal extension being given to the ED director, many other appointments to CAG and many other. Then the electoral cases, the cases of electoral integrity. There was a case in which Common Cause case led to all political parties filing their income tax returns and also keeping copies of it, keeping records of it. We also were co-petitioners along with Association for Democratic Reforms in the electoral bond case. I will not go into it. You know that these were quite consequential cases in India. Common Cause has also been working on police reforms for a long time, since 90s. We were also co-petitioners in the famous Prakash Singh versus Union of India case. We know Mr. Prakash Singh is the prime mover of this case. We are just present, but the very fact that we are there, it shows that we had a commitment to police reforms. Since 2018, we started bringing out the reports called the Status of Policing in India reports. Our first report was about the citizens' trust in policing, their satisfaction in policing. The second report was about police working conditions, how difficult, how challenging are the working conditions of police people. Third and fourth reports were policing in extraordinary circumstances. This came out at a time when COVID-19 happened. So one report was policing and pandemic, and the other report was on policing in extraordinary circumstances like insurgency. So, and after that, the last report that we brought out was on surveillance and the issues of privacy. This report on torture and the question of accountability is more or less about custodial violence. It is by far the most challenging, the most difficult report that we have brought out. We have spoken to police people, as Sanjay ji said, almost 9,000, 8,700 or something police people, personnel of different ranks at different places, at in fact 82 different locations across the country. We have spoken to police people, and we have taken the questions quite frankly, quite directly with them. And I must mention this to you, that all this was possible because of our partners. We had some fantastic partners. We always have Indian Police Foundation as a partner. Many of our senior people are sitting here. So Indian Police Foundation made it possible for us to go into the police thanas across the country and interview police personnel. We also had, in this particular report, we had a very special consultant to work with us, who's one of the biggest authorities on policing in India, called Devika Prasad. I think Devika will be joining us soon. So this report, as you would see, is about unaccountability. It is also about an issue that breaks your heart, that it's in front of everybody that so much violence is taking place, and everybody, the entire apparatus of the country, the criminal justice system and the governance system, are trying to save the culprits. They are trying to save wrongdoers left, right, and center. There is no need to do that. Perhaps it would not happen, or it would happen to a lesser extent if there was probably a whistleblower protection law in the country. Or perhaps if India, like many other civilized countries, had passed their own domestic law against custodial violence. When the police officers, particularly those at the Thana level, know that they can lose their jobs and they can probably end up in jail if they indulge in torture, then perhaps it will not happen. But that has also not happened. So we believe that maybe the findings of this report, of which Radhika will give you an idea just now, will be taken seriously by not just the police establishment of the country, but by the political class and by the policy makers of the country. Thank you.
Thank you very much for your remarks, sir. Moving on, I would now request Radhika Jha to make a brief presentation about the salient features and key findings of the report.
Thank you, Priyanka, and good evening, everybody. So I will, sorry. just. Okay. So the objective of the Status of Policing in India Report 2025 was to look at the nature, the factors, and the causes that contribute to the perpetuation of violence and torture in India. We tried to understand police's attitude towards torture and the extent of normalization of its use in everyday policing. So in terms of methodological tools, we employed mixed methodological tools in this study. We surveyed more than 8,200 police officers from across the country, from 16 states and union territories. And these are police officers of all ranks. We, in addition to this, we also conducted open-ended interviews, in-depth interviews with other accountability actors. These were doctors, lawyers, and magistrates. On their interaction with the police and with the victims of torture and people who have been in custody. In addition to both these, we also analyzed the official data on police excesses and deaths in police custody. We looked at mainly two official sources. These were the National Crime Records Bureau and the National Human Rights Commission. We analyzed data from their publications and also sourced data through RTI applications. The report's major findings altogether basically present a picture that police justify torture to a worrying extent and largely consider its use acceptable in all kinds of cases. Some of the larger trends that appear from that emerged from the study are, one, that there is clear disregard for any legal procedure or due process which are inbuilt safeguards against police torture. The police have a tendency to believe that their role is to impart justice, quote unquote, and the safeguards are basically impediments in their duty to actually carry out their duty. The second important finding that was running through the report was that, unfortunately, the most senior ranks of officers, which are the IPS officers, are in fact the most likely to support torture in various kinds of cases. And these are the people who receive the bulk of the training and the resources and are in the highest positions of authority. Along with them, it's also the officers who frequently conduct interrogation and investigations who are most likely to support the use of torture and police violence. There are also clear state patterns emerging. For instance, Kerala seems to be the state from where officers are most likely to adhere to legal procedures and have lowest support for the use of torture, whereas in the state of Gujarat, there is a much higher disregard for due procedure. They are much more likely, they are amongst the highest support for the use of torture and third degree. They are much more likely to also support other aggressive policing practices like preventive detention or even indefinite arrests without any court investigation. So now running you quickly through some of the important findings of the report. We asked the police personnel on a question on should the police be allowed to arrest and detain suspects without any court investigation, and found that there was huge support for such arrests. 28% strongly agreed with the statement, 41% somewhat agreed, and a total of more than 2 out of 3 police personnel actually feel that they should be allowed to arrest and detain without any court investigation. Again, officers who frequently conduct interrogations and conduct arrests were the most likely to have this opinion. We also find on the process of disregard for due procedure, we find that police have a tendency to justify even the public taking law into their own hands without any regard for whether the guilt of the accused has in fact been proven or not. So we saw that a significant proportion of the respondents said that they support mob violence in various categories of crime. 27% said that it is justified to a great extent in cases of sexual harassment and assault. 25% said that it's justified to a great extent in cases of child lifting and kidnapping. 16% said so even in minor cases of pickpocketing or chain snatching, it is mob violence is completely justified. Similarly, for cow slaughter, 16% said that it is completely justified. The IPS officers and, in fact, the constabulary had the highest support, followed closely by the IPS officers. Whereas the upper subordinate rank of officers, which are basically officers from the assistant sub-inspector rank to the deputy superintendent of police, had relatively lowest support for mob violence. We also saw that more experienced police personnel who have more than 11 years of service or more than 20 years of service are much less likely to support mob violence, and further we'll see that they are also much likely to support the use of police violence and police torture. Across states, Gujarat had the highest support, like I had mentioned earlier. 57% justified mob violence to a great extent. And Kerala had the lowest support. 91% said that it is not at all justified. This was a very worrying finding on the killing of quote-unquote dangerous criminals during encounters by the police. Now 22% of the police personnel that we interviewed said that it is that they agree with the statement that for the greater good of the society, killing dangerous criminals during encounters is sometimes more effective than giving them a legal trial. Even though 74% disagreed and said that legal procedures are important no matter how dangerous the criminal is, but even that 22% is a significant proportion because it amounts to basically more than 1 out of 5 police personnel openly saying that they are in support of encounter killings. IPS and constabulary ranks were the most likely to support this statement at 24%. And upper subordinates slightly less likely, but across ranks there was considerable support for encounter killings. Now, we also asked a set of questions on how regular and how likely is it for certain legal procedures to be followed during arrest. These included questions on completion of arrest memo, completion of inspection memo at the time of arrest, medical examination at the time of arrest, and informing the arrestee of the reason for their arrest. And there is no ambiguity in law that these are to be followed in all cases of arrest, and not following these legal procedures would in fact amount to the arrest being rendered illegal. However, we saw that actual compliance with these procedures as reported by the police themselves is actually quite low, with just 41% saying that they always adhere to all of these arrest procedures. In fact, 1 out of 4 police personnel said that these procedures are rarely or never complied with. Now we look at some of the findings on police's justification for the use of force and for torture. When we asked the police about whether it is okay to use force without any fear of punishment, whether they support the use of force, 26% strongly agreed that in order to fulfill their responsibilities, the police should be allowed to use force without any fear of punishment. 45% somewhat agreed with this statement. On specific questions of the use of violence against certain categories of criminals, quote-unquote criminals, accused in crime cases basically, the police officer also displayed high support for different types of violence. When we asked about the use of violence against the accused in petty offenses, about half of the police respondents said that verbal abuse or threats against the accused is justified. 32% said that actions like slapping or hitting the accused in petty offenses is justified. And 9% even said that third-degree methods by the police against the accused in petty offenses is justified. When it came to serious criminal cases, the support grew significantly. 55% said that verbal abuse or threats are completely justified. 50% said that hitting, slapping, all of that is justified. And 30% said that third-degree methods against the accused in serious criminal cases are justified. Again, the IPS rank officers and those who conduct interrogations are much more likely to believe that that the third degree methods are justified in all categories of crime. And the more experienced police personnel who have worked longer in the police service are less likely to believe so. Sorry. Right, so we created an index on propensity to justify torture by merging together all of the questions, all of the different questions that we had on the use of torture by the police. And overall, we found that there is quite a varying support for justification of the use of torture by the police. 30% had a high propensity to justify torture, 32% had a moderate propensity to justify torture, and 15% very low, 23% low propensity. Now we look at some of the views and experiences of other accountability actors, which were the lawyers, the judges, and the doctors, which were quite in contrast with the data that emerged from the survey with the police. One of the foremost findings that came across from our in-depth interviews with the lawyers, with these accountability actors, was that the victims of torture are mainly people from the most poorest and the most marginalized backgrounds. These include Muslims, Dalit, Adivasis, slum dwellers, people who cannot read or write, etc. Several of the lawyers that we interviewed recounted regularly being stopped by the police from even entering the police station to be able to assist the accused in a crime. Although there was largely consensus on the fact that the magistrate is one of the most important actors in preventing police torture, in reality, the respondents to our interviews actually said that it's very rare to see magistrates play an active role in even interacting with an arrested person, forget about preventing torture. One lawyer described magistrates as silent spectators who did not record anything or ask the arrested persons when and where they were arrested. Some of the doctors that we interviewed pointed out that the medical examination of the arrested persons were not carried out by people who had any specialization in forensic medicines, and in fact were even done by specialists such as eye specialists, anesthesiologists, etc. Basically, whichever doctor is available. In terms of whether the accused is actually able to make any complaint about the torture that they faced, there was largely consensus amongst lawyers and judges that we spoke to say that they are unable to make complaints, mostly because of fear of retaliation by the police and because of the systemic impediments that they face. They also said, importantly, that the National Human Rights Commission is not at all effective in dealing with cases of police torture. When we look at the official data, predictably, the official data on police torture is very scarce, and it hides a lot more than it actually reveals. However, there are some, for instance, one of the foremost things that we looked at was the data on custodial deaths. And there is a lot of discrepancy even between different official authorities in the number of deaths in custody published by them. In the year 2020, the National Crime Records Bureau recorded 76 cases of deaths in police custody, whereas the National Human Rights Commission recorded 90 cases of deaths in police custody. All of the cases of deaths in police custody or death in custody overall need to be intimated to the NHRC, so technically these figures should be matching. And when we look at documentation of a civil society organization, we find that the figure is much higher. The documentation by the National Campaign Against Torture in the same year records 111 cases of deaths in police custody. Again, when we look at the reasons behind deaths in police custody, there is a lot of variation between the official and the unofficial sources. The NCRB suggests that there was only one case of death in police custody, which was caused due to physical assault by the police in that year. As per NCAT, on the other hand, 46% of the overall deaths in police custody were allegedly due to police torture. Now, looking at the disposal of the cases of deaths in police custody, we find that between the years 2018 to 2022, of all of the deaths, just 10% cases had FIRs registered for custodial deaths. Of the 10% cases in which FIRs were registered, charge sheets were filed in just 12% cases throughout that 5-year period, and there were 0 convictions in that entire period. We also found a very interesting finding which corresponds with earlier research on the time of death in custodial deaths. We find that more than half of the cases of custodial deaths actually occur within the first 24 hours of arrest. So in the year 2022, for instance, 55% of the cases of custodial deaths were of those persons who were not on remand. That is, persons who had not been produced before the magistrate. So presumably all of these deaths occurred within the first 24 hours of arrest. Another important mandate, which is, this is last slide. There's another important mandate, legal mandate, which is of judicial inquiry into all cases of custodial deaths. This is given under Section 196 of the BNSS. And although it is required in all cases of custodial deaths, we find that in less than half of the cases, these have been carried out over the last 5 years. In fact, in the latest report of 2022, just 35% of the cases of custodial deaths had judicial inquiries ordered in them. So that is, these are just some of the important findings. There are many more, and I hope that many of you will go back to read the report. All of the reports are available on our website, on the Common Cause, as well as LockNiti website. Thank you.
Thank you, Radhika, and also sorry for bringing the time limit to you. But yeah, thank you for this comprehensive and insightful presentation. Taking the program ahead, I would now request our chair for this evening, Justice S. Muralidhar, and all our esteemed panelists, Mr. Prakash Singh, Ms. Rinda Grover, Dr. Amar J. Sani, and Professor Suhas Palshikar to please come up on the stage for the report release. ये बाद में लगा
Sorry, where do we take very long?
No, but the whole time already.
We didn't take very
I didn't know that it was last time.
You should also take
Yeah. That's it. I would now thank Professor Sanjay Kumar, Dr. Vipul Mudgal, and Radhika Jha, and also request our 3 panelists, and also Professor Palshikar and Justice Muralidhar to be seated on the stage. Let me take this opportunity to now introduce the panel of our esteemed guest speakers for today. We have Honorable Justice S. Muralidhar as our chair and keynote speaker for the evening. Justice Muralidhar is a former Chief Justice of Odisha High Court, having served from 2021 to 2023. He was also a judge of the Punjab and Haryana High Court as well as the Delhi High Court. He has also served as a counsel for Election Commission of India, Law Commission, as well as the National Human Rights Commission for several years. During the 3-decade-long span of his career, Dr. Muralidhar has authored many landmark judgments. Now, a senior advocate practicing before the Supreme Court of Law, Dr. Muralidhar continues to be a strong voice championing the cause of human rights, free press, and preserving the rule of law. It is an absolute honor to have you with us, sir, tonight. Thank you for your presence.
Also represented common cause in the past as a lawyer.
Okay. Also, as our first panelist for today's panel discussion, we have Mr. Prakash Singh with us. Mr. Prakash is a distinguished IPS officer who has served as the DGP for the states of Uttar Pradesh and Assam, as well as BSF. He has also been a member of the esteemed National Security Advisory Board. Mr. Prakash was awarded the prestigious Padma Shri Award by the Indian government in 1991. The landmark 2006 Supreme Court ruling, known as the Prakash Singh Judgment, is named after him, which mandated police reforms in India, focusing on ensuring police independence from political interference and establishing mechanisms for accountability. Thank you, sir, for your invaluable presence with us tonight. As our next panelist, we have Ms. Rinda Grover with us today. Ms. Rinda is a renowned senior advocate and human rights activist. She has contributed to the drafting of laws to protect women and children from domestic and sexual violence. She has also advocated for laws prohibiting torture and for protection against communal and targeted violence. Thank you, ma'am, for gracing us with your presence tonight. Our next panelist is Dr. Amar Jesani. Dr. Jesani is one of the founders of Forum for Medical Ethics Society. He is also the editor of Indian Journal of Medical Ethics. He teaches at many leading universities in India and abroad. Dr. Jesani has co-authored and co-edited 9 books, including his latest work, Equity and Access, Healthcare Studies in India. We thank you, sir, for being here with us this evening. Next, we have Professor Suhas Palshikar, who will be moderating today's panel discussion. Professor Palshikar is the Chief Editor of Studies in Indian Politics. He is also the co-director at Lokniti, a research program of CSDS. He served as professor in the Department of Politics and Public Administration, Savitribai Phule, Pune University. We shall now begin with the panel discussion, and I request Professor Palshikar to kindly moderate the discussion.
Thank you, Priyanka. We are slightly running behind the schedule, and I really don't know what I'm supposed to be doing by moderating the panel, except probably looking at the watch constantly. We have all looked at the report summary that Radhika presented, and there are trends that should worry any citizen of India. The goal of accountability on the one hand and the empirical reality of unaccountability on the other hand is probably a challenge for this panel to address this evening, because the questions are not only about how there is impunity with which police persons behave, but also the questions as to how as society we accept this. And therefore there is this legitimacy of illegitimacy, if one were to call it, that we have to address. The other larger issue probably is what is our description of the Indian state that emerges from such reports and various other reports, data and anecdotes. In trying to become a hard state or a strong state, and recently there have been studies arguing that the Indian constitution wills the state to be a strong state, have we meant by strong state something that is less than democratic and less than civilized? That's the second question. And probably the third question, of which I have been repeatedly talking about, is the question of demand and supply. We talk of people demanding instant justice, and in some cases that is true. But at the same time, is it that our establishment, political establishment, the bureaucratic establishment, as well as the elites generally in this country, really supply for a normative basis whereby they support this idea of police taking law into their hands or police misusing and probably not following the rule of law? So in other words, what is this dialectic of demand and supply that this report and otherwise we come across? These are some of the questions, but I am sure our panelists would be free to interact with us, maybe respond to these questions, respond to the results and trends that the report brings out, or bring to the table fresh issues. So may I first request Shri Prakash Singh ji to open the panel discussion. I would hope that we have probably a second round of interaction with the panelists if time permits. Thank you.
How much time do I have?
I would say 7-8 minutes to begin with, but if you exceed, we can cut short your second round.
Justice Muralidhar, fellow co-panelists, and distinguished persons, ladies and gentlemen among the audience. First of all, I would like to compliment Common Cause and Lokniti for this outstanding report which they have brought about. It's a painful reading for me because it exposes the weakness of the police. I need hardly say that all is not well with the police, and that is why I have been campaigning for police reforms for the last more than 3 decades since my retirement. Not much has been achieved, but yes, we have made a dent, and we have brought this issue in the public platform, and people are talking about it, debating about it. And I would like to thank Common Cause for the immense interest which they have taken in various aspects of police working by bringing out reports almost every 2 years on different aspects of police working. Now, as I said, all is not well with the police, but even then I think things have to be viewed in a perspective which makes you understand 2 things. The other side of the picture, A, and B, why do these things happen? Why are there excesses by the police? Why is there brutal use of force by the police? That needs to be understood. Once you understand, I'm sure you will get a better idea and you will have a better appreciation of the subject. Firstly, we are talking mostly about torture, but what is the definition of torture? Nobody is clear about in India. The UN Convention does define torture, but in India there has been no definition of torture. Would giving a slap amount to a torture? I don't think so. Torture is much more serious. There has to be grievous hurt, there has to be solitary confinement, there has to be waterboarding, there has to be threat of death, things like that. Very, very serious matters. So torture is to be distinguished from a lot of things which we see about police misdemeanor, misconduct, misbehavior, disappointing conduct that we see in the public. Torture is at a different level. That we should understand at the very beginning. Now, Radhika in her report, a very comprehensive report, but if the glass is 70% full, she talked about the 30% which is empty and not about 70% which is full. So I will try to give the other side of the picture also. Now, she talked about torture but the report also talks about tough methods. Now, what are tough methods? That is not defined. But obviously, I would say tough methods need to be distinguished from torture. When you are dealing with hardened criminals, you can't be saying कि भैया आ जाओ बैठ जाओ अरे आप बहुत दिनों बाद मिले आप कैसे हैं चाय पीजिए आपको बिरयानी खिला दें. You can't be talking like that, although yes, this country has a tradition of feeding biryani to terrorists. But you have to be firm, you have to be tough, Now, where is the borderline and where do you cross it? That's a different matter. And when does tough line degenerate into torture? That has to be understood. Now, in the analysis which I read, tough methods are approved by 22% people, and another 35% say, well, somewhat. So it makes 57% of people talk of tough methods and not of torture. 57% people say that while dealing with hardened criminals, you need to adopt tough methods without talking of torture. Then it is true that 22% people say that killing dangerous criminals is to be preferred to protracted long trial. But it's also true that 74% people say that no, irrespective of how dangerous the criminal is, we should follow proper procedures. Now, 74% is to be given more importance than 22%. Then it's also very significant, and this is brought out in the report itself. It talks of police officers saying that great emphasis needs to be given to training in human rights. 79% of the people are giving importance to human rights. 70% of people say that we need to educate our force about prevention of torture. 79% people say that interrogation should be evidence-based. So under all these three heads, the percentage is above 70 of policemen supporting human rights, supporting prevention of torture, and supporting evidence-based interrogation. So this is the other side of the picture. I mean, the glass is, as I said, 70% better, and only 25% is contrary to the expectations. Now, this is another crucial point was use of force without fear of punishment. This has to be. Why is there going to be a debate about it? If force, I mean, why is dandas given to you? Why are rifles given to you? Why are even more sophisticated equipments coming? They are to be used in certain situations. But in those situations, if you are diffident and you are hesitant in the use of force, then you are abdicating your duty. Look, I was interested with the Haryana inquiry, the Jat reservation inquiry, which caused enormous damage to the economy of the state. In fact, as one editor said, that if the Lashkar-e-Toba and the Jaish-e-Mohammed had been given a free run of the country, they would not have been able to inflict as much damage to Haryana as the reservationists did during their agitation. No, that was the damage to Haryana's economy, Haryana's industry. I was interested with the inquiry. I inquired into it. Now, wherever I went, I asked them, why did you not use force when this factory was being burnt? When this library was being burnt, I was so pained. One library kept burning for 3 days. We have heard of Nalanda library burning for 1 month. But I saw with my own eyes a library burning for 3 days. And no force was used. What is the force meant for? If you are not going to use force on such occasions, let the police be disbanded. Let it be disarmed. Can we afford that? I'll put it in a different way. Let us say that tomorrow IAS officers are on leave. Nobody will perform his functions. Would life be very much disturbed? Let tomorrow say the customs department, we are going on leave. Maybe there will be some smuggling. But can police say that we are 24 hours, we are on leave and we will not take any action against criminal? Can you visualize that situation for 1 day? Tell me. You cannot visualize that situation. Why? Because the fear of police is there. And the fear of police has to be there. If you completely remove that element of fear, then you are heading for chaos. You are heading for anarchy. You won't be able to step out of your house and feel safe. The women, the girls will not feel safe going out. Police should be able to use force in situations which warrant the use of force. Of course, the quantum of force which is to be used should not be excessive. Of course, there is no barometer to measure it. But any judicial inquiry generally establishes whether force used was excessive or not excessive. But this is what, and the Haryana officer said that in a particular incident, the superintendent of police, Hisar, had used force to defend his own life. he was being attacked and he could have suffered grievous injuries, if not killed. At that time, he used force and killed a person, and for that he was suspended. He said, since then we know that force is to be used. We are not sure if we will be defended by the government in our use of force. So if factories get burnt, let them be so. Let it be so. If railways get burnt, so let it be so. If crores of property worth get destroyed, let it be so. Who is going to defend me if one person gets killed by my firing? At the most, later on, they will try me for not performing my duty, not using force. But for use of force, the punishment is so severe that it affects my career. So the police, at one police station, I went and say, when they came to attack the police station, they all took refuge over the roof. The police station was left open. They came, ransacked the armory, took away all the weapons, and after that, the superintendent of police goes and says, "Topi utar ke bhaiya hame ye hathiyar de do hame." Now, do you want that kind of a state? Where hooligans can ransack the police station, forget about your homes. And the police officer begs for mercy, कि भैया हथियार लौटा दो वरना मेरी नौकरी चली जाएगी. So force has to be used in certain situations, and police is meant to use force to maintain law and order. And India is a country where you have all kinds of problems. I mean, there is Naxal violence, there is Kashmir you have violence, you have the entire Northeast, you have violence. You have violence everywhere, caste riots, communal riots. How do you deal with them except by using force? Of course, preventive action should be there, but if use of force is inevitable, unavoidable. And when you are using force legitimately in the proper function, in the proper discharge of your functions, in a bona fide manner, you should have this assurance that you will not be punished for use of force. There is no question of any debate on this point, I would say. Another point.
Can we come at the second round for the...
Okay, I'll finish now. Confessions. The report is totally against confessions. Why is anyone sitting here, a lawyer or a judge or a magistrate, why is he more trustworthy than I am? I would like to know. I challenge. The Malimat Committee, which went into the reforms of the criminal justice system, it clearly said that with certain safeguards, confession before a police officer should be admissible. It was all right in British India that you did not trust the police officer, but now these are your own boys. They are the cream of the country. They come from the best families. They come with the best background, and they are most qualified people. Indian police, in fact, Indian police officers are more qualified than police officers anywhere in the world. They are not. You may not be aware, but they are IIT graduates. I am talking of their educational qualification. No, leave that to question answer. I am talking of their educational qualification. They are the most qualified people. They are IIM graduates. They are IIT graduates. They are medical graduates. They are toppers from universities. So, well, why do these things happen? I will end up with that. Of course, there is so many other things to say. Why do excesses happen? I'll just flag the points. I won't be able to go into details because there is a culture. Police culture has been like that ever since the British days, and it's a reflection on our leadership, on our political establishment, that we have not been able to change that culture so far. Secondly, there's enormous police or public pressure, political or public pressure for quick results. That leads to excesses. 3, there is lack of faith in the criminal justice system. कि भैया ये 30 साल तक ये मुकदमा चलेगा, इसके साले का आज की छुट्टी करो. That's why these things. I'm not justifying it. But I'm just trying to explain the circumstances under which these things happen. Lack of accountability. Yes, they know that they can do it and get away with it. Training, deficiencies in training, constraint of resources. These are the factors which contribute to this. I'm not justifying torture at all. And the kind of instances which have been quoted in the book are absolutely revolting, and my heart revolts, my mind revolts. Such things should not happen. What happened at Tuticorin should not have happened. What happened in Tirunelveli should not have happened. What happened in Unnao, where Faisal was killed, should not have happened under any circumstance. Absolutely unjustifiable. I'm not justifying torture, but I'm saying that use of force has to be understood in certain circumstances, and the circumstances under which excessive force is used, I mean, those factors need to be understood. Thank you.
Thank you. Thank you, Prakash Singh ji. May I now request Dr. Amar Jasani to take over to sort of make sure that.
Well, I will speak from here only, and I'm very happy that we have started with a very controversial position here. I think first of all I should congratulate you for doing this job. For a very long time in India, we have talked about deaths in police custody, but we have not talked about torture at all. And worldwide, if you see the history, in 70s, 80s and 90s, after Amnesty International was formed in early 1970s, the torture has been a major area of campaign internationally. Unfortunately, in India, both the official agencies as well as the human rights organizations neglected this whole issue of torture. And as a consequence, you'll find that there was very little discussion about it. And here also what we are talking on this report is torture in a very strongly moral sense, saying that torture is bad. Okay, this is what, if you read the whole report, the premise is very simple, it is bad. Well, yes, it is an ethical problem and it's a moral issue, definitely. But what Dr. Singh said just now, that they can have a very different position. You can have a moral revulsion against it and saying that it is never permitted. Or as he said, that it should be permitted sometime. So in a way, what you are saying is that you legalize the relevant use of the torture, right? And there is a big, moral theory saying that there is a ticking bomb, and in order to find the ticking bomb, you should be allowed to go and torture. This is the window that comes in order to enter and say that, well, torture has some good consequences. That means it is efficacious. It has a capacity to find the truth, and so use it. And that is the, I think, fundamental issue that we need to ask for. That is torture having any efficacy in actually controlling the crime, in bringing people who are criminal or terrorists to justice? And that's where there is no data. I have been looking for it for a very, very long time. And except anecdotal data saying that, yes, I did this and I found that, you won't find anything. We are worried about, the conviction rate being very low in the criminal cases. Why is it so? If torture was really efficacious and in every police station, if it is done, then we should have 100%, right? I remember the debate that took place in early 2000 when narco analysis was being used. Narco analysis came because it was a part of the whole game that came up after 9/11, saying that don't do it in such a bad way that everybody feels, angry about it. Do it in a very sophisticated manner. And I think in political science, you'll find certain papers talking about, liberal democratic torture. And I was reading that article in British Journal of Political Science, and we say that, well, this is very, very important because you involve specialists who actually do torture without creating any kind of physical science and use medical science in order to get it. And if you have a truth serum, I don't think we require Dr. Justice who is sitting here, because we find out then he is not required to make a judgment, because truth is out. Once the truth is out, there is nothing is required, right? And you have brain mapping and all kind of stuff. So this is I think fundamentally one area that we need to look at, that is it efficacious? And why we have not asked that question to the policemen in this report. That they do it, but do they have anything to argue saying that it has efficacy? Do we have, even the elites who are involved there, do do they have any kind of information on this? The Indian police service officers are the most trained and elite people, right? And I'm sure they are being trained in a very scientific manner on torture. One of the role of the medical profession has been to provide the ideas of how to do torture. There's no better torturer that you can get who can do scientific torture in a very efficacious manner, right? I had an experience of, say, being in the police station and being arrested and watching how they work. And these IPS officers don't like the constables who do random beating. Random beating is bad because you get emotionally carried away. Some kind of a sadistic tendency comes out and person dies and there's a big outcry and there is a scandal, right? So I remember being in the police station where the inspector was taking me around because I was under arrest, preventive detention, long back. And he will tell them that this is not the way to torture. The right way of torturing is a very focused scientific way of doing it. And if you do it, you will get information fast. Mostly you don't get information. What I could see that was you get confessions. You get other people getting implicated by the person who is being tortured. But that's, I think, one of the explanation about why IPS officers are the biggest supporter of torture that you have found in this report. Another thing that about the report I can say is from my own experience, this is underestimation. And I think it may have something to do with the way you did the sampling and all, because it's very, very difficult to do this kind of survey. And getting so many policemen to talk to you and also acknowledging that they do it is something very, very, commendable, I would say. I have to talk more about the doctors and their role. I have been involved for a long time on this issue from 1980s onwards. And at the international level, because at the national level I found that if you go and do a human rights investigation and you find that doctor had neglected his duty in actually helping the accused when he was being beaten and brought to the hospital, when we put it down in the report, the human rights organization will say, well, we are fighting against police. Police is the enemy. We don't want to create doctors as enemies, So it will be underplayed when there is a press conference or there is things are being taken forward. But remember that if you want justice, if you want them to make accountable, there are different actors involved. And if that system is not put in place, then we may win few cases here and there, but we will not be able to stop it at the ground level. That means prevention is not possible. What happens to anybody, any person who is tortured, either because of the physical injuries, that person definitely visits doctors. So either police bring, or if he is released from there, he goes to the doctor and doctor definitely finds out that this injury is because of the torture. The other thing that happens, and I think that is oftentimes left out, is that you must have heard about PTSD, right? Post-traumatic stress disorder. The whole disorder that was identified after GIs who came back from Vietnam, and they were suffering from because they indulge in violence and they also witness extreme violence. The people who are tortured, they also suffer from that kind of post-torture syndrome. And I have seen those people going after months because of their mental health problems. And doctors not be able to recognize it and connect it with that, right? So this is a point that I'm making, is that at any time a person is tortured severely, they do come across the medical system somewhere. And that's how it should be one of the focus of our intervention in order to be an ally with the other people who are fighting for the accountability. The another thing that happens is that the person dies in the police custody. I think there is a lot of spotlight on it, but I think there is a small section in this report also, which is very simple, that doctors don't do good autopsy, right? And the whole idea of Ranganath Mishra, that it should be video recorded, has completely failed simply because the videos nobody looks at. You do video recording, but somebody has to do the auditing of it in order to find out what actually happened. And Ginny Loknita and I were doing a report for India about 10 years back. It came out as a part of a book called Does the Torture Prevention Mechanism Work? It was a 14-country study, and India case study was done by Ginny and I. And we were interviewing one forensic expert. And he said that he went through 500 postmortem, or the video recordings of the human rights violation postmortems. And he found that there was nothing in it, in the sense that they used to get videographer from the civil society, and they are very used to focusing it on the main actors. It's very demonstrative. It's like you go to the marriage and you are doing videography there. So where is the focus? The bride and bridegroom. So in the autopsy room, who are there? This is a doctor. His face is seen all the time, right? And the policeman who is standing there, his face is seen every time. And if there is a magistrate who is also there, then that person's face is all the time. While we need video, which is of person who has died and what is happening to that person. Oftentimes, because of our caste system, what is purity and pollution, doctors doesn't touch the dead body. Yeah. They are the assistants of the doctor, the class 4 employees who are from the lower caste. They are asked to cut open, and they just go and look at it, right? And then they pass the judgment. So there is in our autopsy room, according to medical standard, they should be as good as our operation theater. But if you go to the autopsy room, it's worse. Nobody would like in medical college to have their canteen next to the autopsy room, because it smells quite a lot. It used to. I don't know. I haven't been practicing nowadays, so I won't say anything on this. Last 2 points, quick one, because otherwise, one is I think the whole issue of who should be doing medical examination. And I think you had interviewed quite a few forensic experts, and so their view has come out very dominant, saying that there are not forensic experts available. And second is that doctors don't know forensic medicine. Well, if you do MBBS, you are supposed to know it, because that is the subject you are supposed to learn. The point is, these things are not taught. That is a reality, and that we will have to overcome. But what happens at the ground level is that most of the time, these people are not examined by the forensic expert. They are examined by the practicing doctor of that hospital. There may be general practitioner, there may be any kind of specialist in any branch. And I think it is quite justified. It's not only in India. You go to UK, you'll find the same thing, a general practitioner doing it, right? So it's all over like that a doctor doing a job of forensic examiner is a part of the medical life everywhere. Even autopsies, you go to the primary health center, community health center, district health center, it's not the forensic expert who does it. There's other doctors, who carry it out, because they are supposed to know about it. And there I think we'll need to make a focus and say that, well, it's not about the lack of it, but these are the people who are not doing their job properly. And second thing, which is the last point, the doctors are part of our society. Right? As he said that IPS officers are the real elites from the society. Doctors are supposed to be cream of the society, right? Both of them come from the similar strata. And because of that, their support to the torture is the highest. Right? Now, I don't know how many have done surveys of the doctors to find out whether they feel, my first ethical principle is do no harm. Right? And here I am doing harm by actually allowing the torture to continue. Right? So, there is no data available. Except one. In 1995, Indian Medical Association interviewed more than 750 doctors. Now, 90s was a decade when there was a big international campaign on torture. Actually, in 1999, NHRC, Indian Medical Associations, and some other international organization had organized an international conference on torture and medical profession in Delhi. But I don't think there is a memory here, simply because perhaps you people have forgotten about it. It was a big issue, and I was involved. I mean, I didn't have a really good relation with IMA, but IMA was given a lot of international funding to do work on this. Established torture treatment centers in various places. That was one, and another was to get data. And when they did this in 1995 survey, more than 700 doctors, they found that 60% doctors believe that torture is necessary by the police in order to do their job. This is 1995. If you look at now, after 30 years, you may find that that has gone up. And this is a worldwide trend that doctors are a very conservative strata of society, and that's how you require a lot of intervention. Then if you want to change IPS officers, you'll have to do very, very strong intervention. You'll have to do both, not just training. Training doesn't help, let me tell you. I do a lot of training in ethics, and the people who are interested in violating ethics, they come for the training first. Very simple. If I'm doing all kind of bad things, I need to know the law the best. I need to have a best lawyer with me. Otherwise, I can't get away with it, right? That's the thing, right? So it's not, in India, they don't mind doing unethical thing, provided you get away with it. And that is what is happening with the police and with all other actors who are involved in making them accountable. Thank you.
Thank you, Dr. Amar Jasani. Before I hand over to Advocate Vrinda Grover, just one small point. You mentioned that there might be an underestimation. And yes, the report does mention that there is a possibility of social desirability syndrome, and therefore maybe there is an underestimation. Yes, thank you. May I now request Vrinda? Yeah.
Thank you and good evening to everyone. Thank you very much to Common Cause, Lokniti CSDS for this report. These reports are extremely valuable. Even though there may be limitations and we can factor those in, I think this kind of research, this kind of sampling, some analysis, some of the statements that you posed to to the police and others, I thought were very striking. And I really appreciate the work that is done, because I think this is a huge gap in the public information that we have. It's not something that the government is engaging with at all, and therefore any formation of policy, lawmaking, we see a huge gap of information, evidence, data. And of course, these can also become important reports to create campaigns, public opinion, public awareness. So thank you very much for this work. We recently had 3 new criminal codes being brought in, and we were told by the government on the floor of the House in Parliament that the laws are being decolonized, and therefore 3 new laws have been brought in. As we know, BNS, BNSS, and BSA. One of the things that was absent from the colonial law, the Indian Penal Code, was the absence of the offense of torture, one that was committed excessively by the colonial rulers and regime. One would have imagined that this was high time that torture was introduced as an offense. Its silence and omission today is very striking, and therefore compels us to ask, why did the government not want to make torture an offense? The Indian state has ratified the UN Convention Against Torture as far back as 1997. We are in a handful of states that we don't usually like to associate ourselves with. We think of ourselves in a very different domain, who have not ratified. We have only signed we have not ratified. And the reason we have not ratified is that under the Indian Constitution, there is a requirement that a domestic law will be first passed and thereafter the ratification will take place. This is a conversation that the government of India has been having both at the domestic level, including at the Indian Supreme Court, as well as at the United Nations now for a very long time. And the question, I remember in the first Universal Periodic Review, which was perhaps in 2008, the largest number of questions put to India, and it's a peer group, the Human Rights Council. We are part of the UN, before I'm told this is some foreign Soros funding happening here. India is a member of the United Nations. And India was asked, the largest number of questions that were asked was, why and when will the CAT Convention be ratified? And India made an international commitment to do so. From 2008, we are now in 2025 with the law having been amended. We are told decolonized. There is no offense of torture. The crime of torture exists. It exists in the records of the NCRB. It exists in the records of the NHRC, in the media reports, in our experience. Nobody is denying that. The Supreme Court records torture having been committed. The crime is being committed. The offense will not be codified. This is a question that the state needs to be asked over and over again. The issue of, and I don't like, and I think Vipul knows this, I don't like the phrase police reform. I think the appropriate phrase is police accountability. It's not an institution to be reformed. It's an institution which serves the people of the country and therefore must be accountable to the law of the land, not to the political class, but to the law of the land. The issue of accountability of the police, particularly, let's say, in the issue of encounters, was brought into focus by democratic rights groups. The guidelines that we today have in the NHRC, it were the Andhra Pradesh, the undivided Andhra Pradesh democratic rights groups who brought these. The importance and significance of civil society in creating mechanisms of accountability in our democracy cannot be undermined, and it is groups of that kind which have actually moved various institutions, including the court, and Common Cause does it extensively. The definition of torture is not a mystery, nor is there any ambiguity. It is defined in the UN Convention Against Torture, and it says any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for purposes such as obtaining information, punishment, intimidation, or for discriminatory reasons by or at the instigation of or with the consent of or acquiescence of a public official. So, what is the level at which torture steps in is, in fact, if I were to also slap someone, maybe out of annoyance or irritation, actually you can't file an FIR against me. It's not harm injury enough. So law, criminal law, always has certainty and specifies the level and threshold at which the law is triggered. The definition of torture has actually expanded beyond this through the jurisprudence both nationally and internationally. One big gap that I do find in the report, across the world today, including in India, sexual violence, particularly rape, is a form of torture and is recognized as a form of torture. I'm presently on a UN commission, and we are actually recording in times of armed conflict what kind of sexual violence on male and female detainees is taking place, and we are describing it even under international law as a form of torture. And I think there is it's not being said so, but if you read and I read the entire report, it actually misses that part altogether. And I think it's very important to always have a gender lens when we are doing this kind of work. And rape in custody is, of course, as we know, an offense. And therefore, it's not just to be bracketed in a sexual offense, it's also considered a form of custodial torture. The report, very importantly, and a previous report also brought out by the same group of people, had pointed out the kind of, and again an area which is very hard to codify in a sense, but very important to understand in a country like India, about the kind of biases that there are in police officials when they are working. An earlier report also spoke to that. I have been doing for some time a case, a video of which many of you would have seen, of Faizan being beaten by policemen. It's a video that went viral. The men are in police uniform. It becomes hard to say that they weren't doing it. Nobody else was going around wearing the police uniform of Delhi police during the February 2020 Delhi riots. It took us from 2020 to end of 2024 to get the investigation transferred to the CBI from the crime branch, all very elite premier agencies. Unable, I'm sure, as Mr. Prakash Singh said, and he knows the police force better than any one of us, I'm sure they are very well educated and they're top notch, but that must manifest itself in the kind of investigation that we see and the kind of results that we see, because that is the proof of the pudding is in the eating. That video went viral. What does it show? Forget the custodial killing. The boy is dead, young man. It shows that there is bias, institutional bias in the police. Did any senior police officer in Delhi say there is a problem in the police force? Why are they beating an unarmed young Muslim man who, by their own record, did not participate in the riots? They checked every CCTV footage they could find. He did not pick up a stone. Otherwise, there was no chance we were going to get this conversation any further. How come the Delhi Police Commissioner is not alarmed? Why is it not bothering him? Is it all right for the Delhi police to beat, thrash, hold in illegal detention an unarmed young Muslim man? What is it disclosing? This is not just individual bias anymore. There is an institutional bias in the police force. We are refusing to acknowledge, and therefore we don't remedy it and we don't correct it. But we can't run away from it. The definition of institutional bias as in institutional racism set up by the committee, the report of Lord William Macpherson, can be read by all. We don't have time to go into it. But I do think that it is something that we need to reckon with very, very gravely. And it will move us away from, saying, the multiple caveats that are put on use of and infliction of torture. Because we are a plural society. We are a society of all equal citizens. We cannot have a force authorized by law to use force against us if there is bias, and that bias is showing not only against the Muslims. Against the poor it has always been, against Dalits, against Adivasis. There is enough evidence. Maybe those who are sitting in positions where these corrective measures are to take place will not take measures to that effect. Therefore, it will become our responsibility how to initiate those measures, how to campaign for those measures. One important change actually that was brought about, and again I always say this at many meetings, those of you who have heard me, please excuse me. I think when change is brought about by women's movement and by feminist lawyers, human rights movements are very reluctant to accept them. A very important change brought about in the 2013 law, the amendment to the sexual violence and rape law. For the first time, the legal immunity that is granted to public servants against prosecution, which is one of the biggest hurdles of prosecution, an explanation was added, and now it is in the form of a proviso in the new BNSS, that no sanction will be required from the executive if the public servant is alleged to have committed a sexual offense. This was the first inroad ever made into the legal immunity granted under British law to public. Earlier it was servants of the crown, then they became public servants. But the immunity enjoyed by them did not change under Indian law till 2013, only for sexual offenses. The next step is for torture. How can the human body, which is around the dignity of which your entire chapter 3 of the Constitution exists, any torture of the human body, there cannot be the need for sanction. Today, if you were to look at most of the cases where they are stuck, and I have done a fair amount to say this with some responsibility, and this is all documented, so one can verify it. Where do these cases get stuck? At the point of securing sanction from the executive for prosecution. Moving very quickly, there was much talk, including in the report, around the issue of encounter and that whether force can be used and whether force should be used without fear. I've been doing since 2019 the Disha encounter in Hyderabad. It would be important to remember that the letter that was sent to the Chief Justice on the day that the 4 men were shot dead by the Hyderabad police were by women's groups and other civil society activists who said, this is not what women are being seeking in the name of justice. That matter is still continuing. A commission of inquiry set up by a judicial commission of inquiry set up by the Supreme Court of India has held that it was cold-blooded murder. Prosecute all 10 police officers under the then section 302 for murder. What is happening in that case? Every single one of those police officers has extremely senior lawyers representing them before the Telangana High Court. I don't know whether they are able to, who provides the support, who doesn't provide the support. I've not made it my business to find that out, though I think one should. They are all very well represented. There is a battery of lawyers on the other side. We have not yet reached the stage of lodging an FIR. So there is a discourse that is created that the poor cop will perform his duty and then the legal system and these activists will go after him and he will have nowhere to turn. It's not true. Please go and look at each one of the encounter cases and see who is representing the policemen, who is paying the fee of those lawyers. The families of the victims cannot afford lawyers. What has happened in the Disha encounter? 3 of them, 2 of them turned out to be juveniles, 3 of them from a primitive tribal group, the 4th an adult, a Muslim man. This is the India we are living in. And we are not acknowledging that those who are using force, they could have got confessions out of these men that they committed rape and gang rape and murder. Who would have thereafter, after kind of outcry after that young lady doctor's body was found, they could have got the confessions out of them. What is the danger of confessions? Unless there is accountability to law, unless we have those systems in place, I don't think we can even start talking about moving in the other direction. We should not fear the police. I should not fear the police in my own country. I am a citizen. The police is a service force. We should all respect the law, including the man in uniform. I refuse to fear anyone in this country. There is an anxiety about crime. Undeniably, all of us have them. In our homes, for our children, for our daughters, there is an anxiety. Crime is on the rise, and with impoverishment and unemployment, crime will keep rising. So what are we going to do? We are going to keep eliminating people, torturing people, putting them away, giving more and more. Has that reduced crime? So who is preying on our anxieties and who is accumulating more power in the entire process is something that we will have to think about. And there is a very, very insidious, but very, continuing, an insidious process of saying courts are useless. Courts take time. Let's get on with it. Let's get rid of them. It's for all our benefit. And that is what a police state likes to create, and that's what the police wants us to believe. Who is defying the law in this country? And who is the police beating? We all read the newspaper, we see visuals, we walk around. I have witnessed even the 1984. I've always lived in this city. The police did nothing when the Sikh houses were burnt. So it's not about which regime we are talking about, because it's very easy to slot narratives like that. I actually did research and filed an affidavit against the Delhi police before the 1984 Commission of Inquiry. So before you start slotting me with this regime or the other regime. But I've also seen how the police has increasingly become institutionally biased. It depends today who is being lynched, who is being harassed, whose house is being attacked, whose shop is being burned. The police is a bystander. They have the force, they have the authority, they will not use it. Those are the difficult factors for us to reckon with, and torture is therefore today it's targeted torture which is being applied, and that is what we will have to seek answers for. Thank you.
Thank you. Friends, I have many responses and questions to the panel, and I am repressing myself. The panelists themselves also have responses to each other and requesting them to repress themselves. So also you all. And let us therefore request the keynote speaker, Justice Muralidhar, to deliver his keynote address. Thank you.
बहुत हो गया। एक छोटी कहानी सुनाता हूँ। एक बड़ा कंपटीशन था, वर्ल्ड्स बेस्ट पुलिस टीम। आप में से बहुत सुने होंगे इसको। एक ट्विस्ट दे रहा हूँ इसको। तो कंपटीशन काफ़ी सिंपल था। एक घना जंगल है फ्रांस में, उसके अंदर बिना हथियार आपको जाना है और एक लोमड़ी को पकड़ के लाना है, बस इतना ही है कंपटीशन। तो पहले यूएसए की टीम जाती है और उन्होंने मीटिंग कॉल जो होता है ना, वो परफेक्ट किया है उन्होंने। तो बस 10 मिनट में आ जाती है, लोमड़ी को पकड़ के लाई आते हैं, काफ़ी तालियां। उसके बाद फ्रेंच टीम जाती है अंदर। तो ये फ्रेंच लोगों को परफ्यूम का बहुत शौक़ है। वो फॉक्स का सेंट का जो है ना परफ्यूम स्प्रे किया यहाँ वहाँ पेड़ पर, बस 8 मिनट के अंदर लोमड़ी को पकड़ ले आए। अभी तीसरा टीम जाता है पीपी से। पीपी मतलब देखिए यही है प्रॉब्लम आपके साथ। सिंह साहब बैठे हैं, पाकिस्तान पुलिस, पाकिस्तान पुलिस, पाकिस्तान में भी पंजाब है मगर ये तो पाकिस्तान पुलिस। पाकिस्तान पुलिस से 2 हवलदार, वेरी सैडली वो लाठी को छोड़ के जाना पड़ रहा है उनको। अंदर जाते हैं, 11:30 होगा, आधा घंटा हो गया, 1 घंटा हो गया, 2 घंटा हो गया, लंच टाइम पार हो गया, टी टाइम पार हो गया, सनसेट भी हो गया है। तो इनको ढूंढने के लिए एक टीम भेजते हैं और टीम बहुत घने जंगल के बहुत अंदर जाती है और अंदर से एक चिल्ला के एक आवाज़ आ रहा है। तो वहाँ जाके देखते हैं 2 पेड़ के बीच एक भालू को बांधा है और अपने बेल्ट से लेके उसको मार रहे हैं, ये कह के कबूल कर तू लोमड़ी है। दिस इज पार्ट 1। बेचारा भालू तो कुछ कह रहा है। तो ये जब टीम जाती है, अपने हवलदार पूछ रहे हैं व्हाट इज दिस भालू सेइंग। तो फ्रेंच का कुछ भाषा होगा शायद, तो वो अनुवाद से बताते हैं ही सेइंग आई एम टोटली फॉक्स्ड। और ये बहुत एक्साइट हो जाते हैं, मान गया मान गया। Sorry, Vipul, for this distraction, this interruption. I have to apologize one more thing. I actually wrote out a detailed keynote address, but at the same time I was drafting a letter to my dear friend Justice Ramasubramaniam. Now in the hurry I got that speech instead of my keynote address. So with your kind permission, could I read that letter? So the letter goes somewhat like this. Dear Justice Ramasubramaniam, Ram, don't be surprised that I'm calling you like this. I know we got sworn in around the same time as High Court judges, and we've known each other for long. But there is a possibility that I might read this letter by accident in a public meeting later today. I was very happy when you were chosen as a chairperson of the Human Rights Commission. By the way, I must tell the audience, I have a pretty bad stenographer, so please excuse me if there are typing errors here. Ram, I was very happy when you were chosen as the chairperson of the NHRC. Everybody knows in this country that the choice is by a committee. Now, you were chosen by a committee comprising the Prime Minister, I'm sorry, this typing error is, please pardon me for this typing error. It should read the Prime Minister, the Speaker of the Lok Sabha, the Home Minister, the Deputy Chairman is Rajya Sabha, and 2 anti-nationals. Again a typing error. One is the leader of the opposition, the Rajya Sabha, and the other is the leader of opposition, the Lok Sabha. So we're very happy, Ram, that you were chosen as chairperson of the NHRC. And in the very first speech, I can understand when you addressed upon taking over on 30th December, you harked back to our traditions. You said human rights is not a foreign concept. Our Tirukural also contains passages on human rights. You are a great scholar, Ram, in Tamil. And I know that you had that urge to refer to a Tamil text. But these days, Ram, it's better that you refer to a Hindi text. Tamil is not a very popular language. Ram, you should also realize that, as we know in intellectual property rights, certain words acquire secondary meanings. Ram, I know it's useless to tell you this, but for instance, when Xerox was the first corporation to make photocopiers, people used to, after a few years, say, "Mujhe ek Xerox de do." Xerox is the name of the company, but it required a secondary meaning. So likewise, there are words that acquire secondary meanings in our country, and the whole context changes. Now, I'm in the grandfather age, so are you. So one of my classmates was narrating this. He's a retired IAS officer now, and his grandchild was asked in school, "Who's your favorite relative?" And as many children say, "My grandfather" or "my grandmother." So this boy has said, "My grandfather." So what is it about him that makes you like him so much? One child said, "My grandfather, after his retirement from the IAS, is now the epitome of reliance." Such an innocent statement. I don't know why it caused a flutter. Another grandchild was asked, "Why do you like your grandfather?" He said, "My grandfather is very spiritual and he entirely relies on Vedanta." So Ram, you'll realize how new meanings are attributed by all people with suspicions. These are all innocent words, unnecessarily twisted out of context. Now let's take this retired police officer from Andhra Pradesh. He was narrating his woes to me. He said, "Sir, I've been leading a peaceful life." In an ordinary conversation with another colleague, I said, "I used to have a girlfriend called Ishrat many, many years ago, and we had a falling out. And then the other day I encountered her on the way to Adilabad. Now this was a perfectly innocent statement. Why should it cause an inquiry against me because I used the word encountered? Is it not a simple English word? One other from the police, Punjab police said, "Sir, I have known this boy for so many years. A very nice boy. But you know, after 1995, he simply disappeared." Now that police officer got into trouble. So ordinarily innocent English words have become distorted. And Ram, as chairperson of the NHRC, I'm sure you will do your best to deal with all this distortion of words that have crept into the Indian language. But worse still, Ram, these have crept from the English into Hindi. You know, the other day, Ram, I was arguing a matter in the Bombay High Court. It was a criminal case. So one of the suspects, after making a confession to a police officer, and Mr. Prakash Singh is absolutely right. Why is it any better than making a confession to a magistrate or confession to a lawyer? What is wrong in making a confession to a police officer? So after making a confession to the police officer, he goes before the magistrate and he narrates, "Sir, my sister, my mother, they were also brought before me. They were tortured in front of my eyes." And then the police officer said, "Abhi isme sign nahi karoge, to main aapka encounter kar dunga." That's when I realized, while I was arguing, that encounter is not a Hindi word. Earlier we thought it's only an English word. And they said, "Main aapko third degree bataunga." So third degree, encounter have all traveled from the English lexicon into the Hindi lexicon. So words acquire secondary meanings, words acquire excellent meanings. Like we had heard this evening, सवाल का जवाब देना है, प्रश्न का उत्तर देना है. प्रश्न प्रदेश नहीं बनाया हमने, उत्तर प्रदेश बनाया हमने. अभी वो उत्तम प्रदेश बनवाने वाला है और विकसित भारत में सर्वोत्तम प्रदेश बनेगा वो. So Ram, even these words, like for instance, hak, ya adhikar, most people in constitutional offices today believe that these words need to change. जब भी अधिकार की बात होती है, Ram, we immediately say, what about duties? So kartavya is very important. And these are the days, Ram, when name changing is quite common. So as chairperson of the NHRC, it's only my suggestion that you might want to consider a popular demand by a majority in this country that, of course, you should become a Vishwaguru of human rights commissions. So you should represent yourself as a Vishwa Manav Kartavya Ayog, where one of the main tasks you will have is to enforce duties. For instance, there should be a fundamental duty in every citizen to not cry when tortured, not suffer unnecessary injuries when tortured, and not have bleeding injuries or broken bones when tortured. This becomes a part of your patriotic duty. Because after all, as we are told, police is only performing its duty. Then this word bulldozer. And bulldozer is now associated with maternal uncle. I'm writing a letter to the NHRC 7, you will not realize. Ram, the word mama is the same both in Tamil and in Hindi. It still means maternal uncle. So we have constitutional office holders who are called maternal uncles, suffixed to the word bulldozer. I would be very curious to know, Ram, whether it's of any concern to the NHRC that houses of people suspected to be involved in riots are straightaway demolished. would it really concern the NHRC? I want you to also scotch baseless rumors, Ram, that are doing around. One rumor is NHRC should not register complaints received from ruling party ruled states. This is a totally baseless rumor, and as chairperson of the NHRC, you must put out statistics to show how many complaints from Uttar Pradesh you've received and how you've dealt with it. That will help us scotch these rumors completely. This is becoming a long letter. Today evening, Ram, I'm going to go to the event after having read a report, which is all kinds of statistics. They claim to have talked to 8,000 policemen, lawyers, judges, civil society activists, and they've come up with all sorts of figures. For instance, very interestingly, in page 30 of that report, and I'm sure, Ram, you'll probably get to read the report, just to give you a kind of heads up. In page 30 of the report, they've set out 12 methods of torture. In fact, one of our panelists had a doubt, what does torture even mean? This report tells us there are 12 different kinds of torture. For instance, beating with lathis, torture from suspension, stretching limbs apart, prolonged constraint of movement, beating while suspended, cigarette burns, electric shocks, choking, rubbing salt, chili pepper, gasoline in wounds or body cavities, sexual violence to genitals, molestation, rape, conditions of detention, unhygienic conditions in police lockup, prolonged solitary confinement, blocked access to toilet facilities, irregular access to food and water, denial of privacy, forced nakedness, humiliation such as verbal abuse, insults to caste, religion, community, performance of humiliating acts, threats of death, harm to family, further torture, imprisonment. And Dr. Jasani was telling us about this. Psychological techniques to break down the individual, including threats of imprisonment under harsh laws, denying meetings with family members, hostage taking of family members, forced to perform acts against one's religion, forcing the victim to witness torture or atrocities being inflicted on others. I know, Ram, you're a very learned person and you've read widely. If you think this is just copied from the Guantanamo Bay Blue Book, you're mistaken. These people have talked to at least 8,000 policemen and have gathered these details. So it might be useful, Ram, as an HRC, to say what you want to say about these. You could either deny this, or you could endorse part of it, or you could do something about it. One is to write to all the policemen in this country and ask them, is it true that you use these different forms of torture? And you can find out if what this report is saying is wrong or what they are saying to you, which is otherwise is right. But I think this is a good point for you to start with, this report itself. Then, Ram, you should tell us what the NHRC is doing about all those Supreme Court guidelines it issued on encounter killings in the PUCL case in 2014. Then on the DK Basu guidelines on arrest. Then the CCTV cameras everywhere placed. Then you have your own guidelines. Again, Dr. Jasani talked to us about it. All those CDs that have been sent to you in the NHRC. Would you mind putting all those CDs on a public platform? Or for people who are interested in research, could you give them copies of that so that they can themselves find out what those CDs contain? Could you in your report set aside one whole section to say when did you receive such a CD? When did you take action on it? And what was the remedial measures taken? You could also deal with soft issues. What are soft issues? Just like we were told now, imagine if all policemen stopped to work. So I ask myself, imagine if all the sanitation workers stopped to work. All the sewer cleaners stopped to work. We would have a real health crisis. So your human rights mandate, fundamental duties mandate requires you to inquire into the lives of every Indian. And these are Indians working tirelessly and with compensated very little. Whether they are working in the mortuary, as Dr. Jasani pointed out, or they're working in their sewers and dying every day. Their also lives matter, their rights matter, their protections under the constitutions matter, their dignity matters, and it should matter to you as an institution. Lastly, and before I end that part, so you might have people from those constituencies coming to you at the NHRC, knocking at your doors, and they must be shouting Satyameva Jayate. Of course, you can answer to them saying Swachhameva Jayate. But this is a constituency that requires your attention and your immediate action. And lastly, we are in the stage of Amrit Kal and Viksit Bharat. And Ram, you know that earlier we mistakenly thought Naxals were only of one category. Now we have a rural category and an urban category. So Ram, if somebody tomorrow comes, and you know in the NHRC it's very common to have UN representatives. So somebody says I'm a UN representative, you better be doubly sure that it is UN representative. So you might want to have a complete section in your report, and I know I'm saying this in a place in Lutyens, Delhi, near Khan Market, addressing a gang where, barring one person on the panel and a few others maybe in the crowd, everybody looks like a Tukde gang to me. So Ram, you may want to devote an entire section to UN, and by now you know what I mean by UN. And thank you for the audience for listening to this letter to Ram.
As the evening nears its fruition, with such an insightful panel discussion and keynote speech, I take this valuable opportunity to thank Justice S. Muralidhar for his extremely interesting keynote address to the audience. A heartfelt thanks is also due to Mr. Prakash Singh, Ms. Vrinda Grover, Dr. Amar Jesani, and Professor Suhas Palshikar. We indeed had a great time listening and thinking along the discussion and being a part of the session. I would now invite Professor Sandeep Shastri, Vice President, Nitya Education Trust, and the National Coordinator, Lokniti Network, to deliver a vote of thanks.
Excuse me, can we have one question?
Sorry, one is never enough, so sorry.
One remark at least. I think all the questions would be best at the dinner table, where along with our sumptuous dinner, not only food for the body, but also food for thought can continue there. Friends, after a keynote address which left everybody waiting for the next word to be said and the next sentence to be articulated, words fail me in being able to thank you for having joined us this evening and made this evening so special for everybody here. Thank you, Justice Muralidhar, for being with us today at the release of this report. I would also like to thank all our three panelists for their very insightful comments and for the dialogue which happened between them. I wish we had more time for that dialogue, but then there is always a limit of time that we have. So thank you all for doing such a commendable job. I must also use this occasion to thank everybody in our audience for coming here. I think it's after a long time we have had a hall where people have had to stand for 1.5 hours, and they have done it happily. So thank you all of those in our audience for having spent this evening with us. And I'm sure each of you will go back with new ideas, fresh thoughts, and will look at the issues which this report raises. On behalf of Common Cause and Lokniti, I'd like to thank, in a very special way, the Indian Police Foundation, particularly its president, Mr. N. Ramchandran, the former DGP of Assam and Meghalaya, and many other members of IPS like Dr. Ish Kumar and Ms. Miran Borwankar for their support in the work we have done. We're also thankful to the global academics who gave feedback on the survey questionnaire that we developed. These included people like Beatrice Jauregui, Abhinav Sekri, Gagan Sethi, Vijay Raghavan, Ginny Lokanita, Ramesh Nathan, Vibhuti Narayan Rai. The Common Cause and Lokniti are especially thankful to our special consultant for the project, Mrs. Devika Prasad, and we also would like to thank all those who agreed to be interviewed for this study. Finally, a lot of people in Common Cause and a lot of people in Lokniti contributed to the success of the study we did. We had a range of field investigators across the states who did our data collection. A very big thank you to each of them. I think the best credit to this report would be the feedback we received from you on this and your support in spreading the message which this report contains. Thank you all for being here and have a wonderful evening.
Thank you, everyone. I would request everyone to please join us for dinner. Thank you.